make a start. So, yeah, good morning, everyone, and thank you for joining our webinar on the Social Housing Regulation Act 2023, which are going to start coming into force, the main changes later this month. Today, I am joined by my colleagues, my colleague Ella Baker, who runs the housing casualty team in our Farnborough office. But most of the heavy lifting this morning will be done by John, Roxanne, and Hazel from DAC Beechcroft. The session will be recorded. We will send out a link to the recording as soon as we can following the sessions. We should have time for questions at the end, so please feel free to submit these using the Q&A function. And yeah, thanks again for joining us this morning. So, the Social Housing Regulation Act 2023 was introduced to address serious and long-standing issues in the social housing sector in England and Wales following a couple of high-profile events, and particularly the tragic death of Al Abishak and the public outcry and media coverage that followed the inquest in November 2022. Awab's case was seen as identifying a need to reform and improve social housing conditions to prevent future tragedies, which has led to the regulations that come into the force at the end of this month. Now, the regulations introduce some additional dimensions of liability exposure that we will be exploring in this morning's session. And I will now pass you over to John and the team from DACB to take an in-depth look at what these mean.
Good morning, everyone. I'm really pleased to be here and great to see so many people joining. So as Daniel said, I'm going to lead off. As Daniel said, my name's John Goodman. I head up public sector in DACB, acting for a sort of wide range of local authorities and housing associations. I will just very quickly hand over to Hazel and then Roxy to make sure their vocal cords are working this morning. Hazel, just want to say hi.
Hi everybody, I'm Hazel James. I've been at DAC Beechcroft for 6 years now, and I work with John in public sector.
Hi, I'm Roxy Mitchell, and I'm an associate, and I've worked with John Goodman for many years. So yep, exciting to talk about housing today.
So I will go through what this is all about, what the changes are and the specifics, and also dealing with possible defences which are important to bear in mind. And then Hazel and Roxy are going to pick up on what can we do about it, what's the best response to all this. So I'm going to go straight to what this is all about. And I think it's quite important actually to get a handle on the kind of legal structure of this. So most people probably on this call know that there are implied statutory covenants, which are basically just implied terms in tenancy agreements. We've got the duty to keep in repair the structure and exterior. You've probably heard of that one. We've got, from 2019, we had a new one, fitness for human habitation, and again, an implied term into every tenancy agreement or lease under 7 years. So what this is basically a new implied statutory covenant. That is the way that they've responded to that kind of, as Daniel said, that massive public outcry over specifically Al Abishak's death and the coroner's report. So the way it works is that there is a new section 10A2 in the Landlord and Tenant Act 1985, which says that landlords must take action in relation to certain prescribed hazards. And if you don't take action, then that last point there, you are breaching the tenancy agreement. That is a breach of the new implied statutory covenant in
Sorry,
the tenancy
John.
agreement.
Sorry, John,
Yeah.
we've gone back to the intro slide, so I just wondered if you can double check on your screen if you've got
Mine
control.
is showing the right one. That's strange. Okay.
Mine's still showing the right one.
Okay.
Oh.
Is it showing the right one for everyone? Okay, it might just be at this end. Apologies.
No, don't worry. Okay.
Hmm.
Yeah, are we all right? Yeah. Let's just
Cool.
Okay, so so the issue is what are they talking about? What prescribed hazards does everyone have to take action to deal with? So I'm going to, Daniel, does this work for you if I've just changed it? Oh, you're on mute.
Yeah, got it. Thank you.
Good. Okay, so what it relates to is the Housing Health and Safety Rating System, which came in with the Housing Act 2004. And what they've said is that over time, the government wants to bring in fixed timescales to respond to all of those 29 hazards, apart from overcrowding. But they're going to do it in a phased way. So the thing that's coming in at the end of the month, literally 27th October, is any emergency hazard and any complaint of dangerous damp and mold. And so that is coming in 27th October. And so that's what we're going to look at today. And this is really the absolute sort of headline point. It does include any emergency hazard, so a major fire, flood, ceiling completely falling down, whatever that you would consider an emergency hazard. But we're going to kind of probably set that to one side because it's really damp and mold that we are looking at today. And I think the broad picture of these new regulations, which came in there, you can see there, they came in 25th June, so very, very recently. Not a huge amount of time to prepare for this, it has to be said. Excuse me. The broad picture is that all complaints that are made of damp and mold, which are potential hazards, we'll look at this in more detail, but the overview is that all complaints which come in, whether it comes into a complaints officer, whether it's online, even if your own officer spots it in a property, they must be responded to within fixed timescales. And broadly speaking, the thing is divided into two. So there are very, very tight timescales to make safe, to do immediate safety works. And then there are kind of a bit more realistic, reasonable timescales to actually rectify underlying problems. That's the kind of big division of the two. So drilling down into a bit more detail, day zero, you have a complaint that's made either by a tenant or someone else, could be someone visiting the property, could be your own inspection, and you need to be doing an initial assessment. You need to kind of hit the ground running, really, with an initial assessment. And you need to be assessing three, really what it comes to is which of three categories are we talking about? And we're going to look at each category in detail. So what we've called it Cat 1, Cat 2 and Cat 3, just to make it easy. You'll see there's a bit of a theme to this morning in terms of, we think in a way you need to move to a kind of almost like a highways type of thinking about this whole thing, and that's very much how highways departments think in terms of hazards on the highway. So Cat 1, is it a potential emergency hazard? So you ask yourself, well, what actually do they even mean by that? And the definition is an imminent and significant risk of harm where a reasonable social landlord would make safe within 24 hours, e.g. prevalent damp mold impacting health. So immediately that's a bit of a fudge, isn't it? I mean, so what they're saying is you need to investigate and make safe a complaint of damp and mold, which a judge would expect you to make safe in 24 hours. I mean, that's really what that comes to. So it's not a massive amount of use. But I think, the key really is in this word emergency. You are talking about a very, very bad situation. And in a sense, it would be surprising not to know about that before. You're talking about, a massive development of damp and mold in a tenanted property. The photos that came out of the Awa Abhishek case were just ghastly, absolutely dire. You probably are, talking about something in that realm. So I think it's going to be hopefully quite rare that you are talking about a Cat 1 potential emergency hazard. But let's say that someone does report, a massive problem, which clearly needs a very, very rapid response. The timescales are these. You've got to investigate and make safe within 24 hours of being told about it, which, I mean, I'm not an expert, but presumably that means, a major kind of mold washing exercise, dehumidifier, that sort of response. If you can't deal with it in 24 hours, you need to move the tenant family out, which obviously raises sort of major questions of, how much capacity have you got to actually decant your tenants. And thirdly, you need to provide a written summary to the tenant of your findings of that investigation within 3 days of concluding the investigation. So that's kind of the immediate response. You can see that the timeline is really tight. You've got to not just investigate in 24 hours, but you've got to make safe in 1 day as well. The bits at the bottom are the longer term stuff. So you've got to begin to take steps to do any further required works to prevent a recurrence within 5 working days of concluding your investigation, or if not, as soon as reasonably practicable. So you can see there's a bit of kind of leeway there. There's a bit of comfort being given for that second stage for the dealing with the underlying problem. You've got to physically start the works within 12 weeks of concluding the investigation, and they've got to be completed within a reasonable time period. So there's quite a lot of reasonableness there you can see in that second stage, which there isn't in that first make safe period. It is absolutely right, 24 hours, investigate, sort it from a safety point of view. Okay, how does that compare to Cat 2? So potential significant hazard, not an emergency, but a significant hazard, defined as significant risk of harm to health and safety of the tenant, taking into account the age, physical, mental health issues, and potential severity of harm. So you do probably really have there, 2 factors you've got to think about. You've got to think about the tenant themselves and any particular vulnerability, and you've got to think about the actual problem. I think it's quite important to note here that you are talking about a significant risk of harm to health and safety. So this is where we don't know how this is going to play out, but it just seems to us that even here you're talking about something pretty bad. So, a little bit of damp around a window, I wouldn't have think that, wow, there's a significant risk to health and safety there. So I think in a way, this doesn't necessarily capture all reports of damp and mold, apart from the emergency ones. I think that's a kind of probably the wrong way of looking at it. You are talking about pretty bad situation here, even if it's not an emergency. So if your assessment is putting the complaint into Cat 2, how long have you got? Well, you've got to investigate within 10 working days of the complaint. you've got to make safe within 5 further working days after you've investigated. And again, if you can't keep to those timescales, you've got to decant. And similarly to the emergency scenario, you've got to provide a written summary to the tenant of your findings within 3 working days of concluding the investigation. So again, you know, pretty tight time scales. I mean, obviously we're conscious, we're acutely aware of the lack of resources in terms of repairs and responding to complaints, and the difficulties, you know, with the kind of quality of the housing stock. And this is still, you know, a pretty tight timescale. That second stage is exactly the same. The underlying repairs deadlines is exactly the same, but we've just sort of reprinted them there just so that it's all together. Take steps, or begin to take steps, to prevent a recurrence within 5 working days of concluding the investigation, or if not, then at least do it as soon as reasonably practicable. Works must be physically started within 12 weeks of concluding the investigation, and they must be completed within a reasonable timescale, and keep the tenant updated. The third category, a little bit of relief here. You just don't think it's either category 1 or category 2. Now that slide, we leave probably a bit of a health warning on that slide actually. No action needed in terms of this new AWAB's law requirement, but it may be that you've still got to deal with that. It's just that it doesn't come under these fixed timescales because it's not an emergency hazard. It's not a significant hazard. Therefore, it's what we're calling a Cat 3 outside of AWAB's law. So that is the basic structure of the thing. Some initial questions that are dealt with in the guidance, just to flag up. What if you investigate it, you think initially it's a Cat 2, you look at it and you think, actually, this is really bad, this is worse than we thought. Then it does switch to a Cat 1 and you need to treat it as a Cat 1 as soon as you're aware. What sort of person should be doing the investigating? The guidance says a competent person, so it's fairly general, but that's the sort of definition. In terms of how can these investigations be done, they don't have to be done face to face, in person. They can be done by remotely by a camera, but the tenant does have the right to insist on it in person, which is, you know, potentially a bit of a pain, but they do have that right. What about a case that you're dealing with now or that comes in before 27th of October? The guidance says that if there's any further complaint or report from that tenant, then it does trigger the AWAB's law timescale. So the fixed timescales will apply from then. And again, if there's some kind of material change which is reported, then the AWAB's timescale starts again as well. So before handing over to Hazel and Roxy in terms of what is our suggestion for how to respond to all of this, quite important to know what exceptions there are, any defences, any exclusions. So we're going to just sort of run through those. The first one really is something that hopefully will be clear from the start, and it's kind of the reason why I wanted to make clear what the legal structure is. This is a contractual claim under the tenancy agreement. So this is not some general right in negligence. So it does mean that only the tenant can claim. I suspect we're going to get letters from claimant lawyers saying that, oh well, this defines the duty of care, this sets the new standard for negligence. So I think it's quite important to hold the line that actually there is no general duty of care flowing from a landlord to a tenant. It's something that claimant lawyers kind of struggle to understand. That's why you get these implied statutory covenants put into tenancy agreements. But this is just a right for the tenant as a party to the agreement. Big issue, obviously, in damp and mold historically has been this kind of responses saying, well, it's a lifestyle issue. You're not opening your window, you're developing condensation, you need to be dealing with that. And that's been kind of quite heavily frowned upon in the coroner's report, in the housing ombudsman's reports. I don't think this new development, this new law, completely counts out a lifestyle argument, if you like, but I think you do need to justify it quite carefully. That the guidance says that it's unacceptable to assume it's lifestyle only, and I think the key word there is assume. You do need to be able to back that up. But the guidance does state that there must be some defect or disrepair or lack of maintenance which is causing the damp and mold. So that is still kind of an issue that's in play. If it's not your duty to repair, then you've got no duty. If you're not in control at all, then simply no duty. And if the tenant has basically trashed the place, a breach of contract by the tenant, then no duty there either. Those are all kind of preliminary things, and now kind of the main defence, which is really important to know about. Section 10A5, Landlord and Tenants Act. If you have taken all reasonable steps to comply, but you cannot comply for reasons beyond your control, you have a defence to a claim. Now, the obvious example of that is you've had a complaint, you've contacted the tenant in time, but you haven't been able to get access. And we know from lots of our clients that, this does happen. And I think one thing that Roxy and Hazel will be talking about is we're lawyers, we need evidence that you have tried to make contact. But it could also be that, you need some specialist contractors, you haven't been able to get them in time. You need a building control, you need planning, approval, that sort of thing, in terms of the underlying work. So that is, an important defence to know about. And just wrapping up this section before handing over, what if there is delay, but it's purely down to your panel of contractors? That doesn't get you out of a breach of contract claim, although of course you may have be able to have a recovery claim from the contractors. What about long leaseholds? They're excluded. We're only talking about tenants. We all know that we have vexatious tenants, vexatious claimants. If you get complaints again and again and again, with a tenant thinking, well, I'm just triggering the timescales, this is marvelous, then that is catered for in the guidance, which is kind of a bit of a relief. You only need to reinvestigate if there has been a material change. So you are entitled to say, we are not dealing with this 19th complaint because we have no reason to believe that there's been any material change. There's also specific reference to if you need a structural survey, then that can be an excuse for not being able to do the underlying works. You've still got to make safe, but at least that's a justification. And of course, just finally, really, there has to be an emergency or a significant health hazard, and in a sense, that's the most important thing. And it's something that will develop over time, I think, and almost what would be good would be for social housing landlords to develop agreed standards of what they consider to be emergency or significant health hazards. So that is a run through the main provisions. How are we going to respond in practical terms? I will hand over to Hazel to start with. Thank you. There will be time for questions at the end, by the way.
Hi, everybody. As John explained, I will be dealing with that part of the talk, which hopefully be helpful in a practical way of dealing with these types of claims. Just a quick reminder of why I think this is one of the biggest game changers in housing law since the Landlord and Tenant Act, probably. A reminder, you've got 24 hours to investigate a potential emergency. You've got 10 working days to investigate any potential significant hazard. You've got to produce a written summary within 3 working days, and then you've got to undertake relevant safety work within 5 working days, and you've got 12 weeks to undertake the works that is required. Okay, so now whilst the focus has been on, AWAB's law has been on damp and mold, the wording of the law in time will require all social landlords to address reports of not only damp and mold, but all of the 29 hazards specified in the Housing Health and Safety Rating System, Regulation 2005. Now, with the exception of myself, is there anybody else who knows 29 hazards? No? Okay, let me just give you a flavour. So we've got damp and mold, we know, complaint of excess cold, complaint of excess heat, so threats due to high indoor temperatures, complaint of exposure to asbestos, complaints dealing with lighting, so threats to physical and mental health associated with inadequate nature, natural or artificial light, complaints of noise, so threats to physical and mental health due to exposure to noise within the property. There's another one is food safety, threats of infection from food, from poor provision of facilities to store food. The list goes on and on and on. So there's 29, although I have read somewhere that they're probably going to reduce that. So 2026, these other hazards are going to slowly be rolled out. So this is, we're focusing on mold and damp at the moment, but eventually this is going to just blow the door open. So hopefully I'm going to impress upon you how serious this is and how you've got to get yourself organized and prepared in time. So these are some of my practical tips and steps that I think you can, we think you can incorporate to cope with the new law. So you'll see my slide up there. This, John, can you put it back one? Sorry, it's the one before. That's it. Now, the first tip is to ensure all maintenance staff and contractors are aware of the 29 hazards. How to identify the issues in emergency repair and the appropriate time frames for resolution. So it is vital that all reports of damp and mold are addressed and promptly dealt with, but also that staff are looking for any underlying cause of the damp and mold and will take immediate steps. So it's not just your staff, but your contractors. You've got to get contractors on board and make them aware of their obligations under the new law. My second point is assess whether repair teams and contractors have the capacity to meet the timescales, including weekend work. Now, I say that because obviously you've got 24 hours to make that initial investigation. It could be a call on a Saturday, so you've got to get somebody out on a Sunday at the latest. Contractors have to have the capacity to deal with that. They have to have the capacity to deal with the turnaround times frames, because if they fall foul, you're the ones that's going to be holding the issue, have to deal with the issue at the end of the end of the day. My other tip, which often gets a bit of a laugh, is investment in staffing levels. Now, yeah, the last time I proposed that, I did get a laugh from the crowd, basically employing people to come and deal with housing claims and deal with these specific issues. I mean, if you spend on staff now, this will probably help to reduce your overall legal spend further on down the line. So I think it's probably an investment worth considering. My other tip is review contractors' relationships. So do you have trusted contractors who will be able to ensure the issues are resolved promptly and adequately? If not, the appropriate indemnities, do you have indemnities in place so you can, if they failed to adhere to the time frame, can you pass on any potential claims to them? You might want to look at your indemnities there. You may also want to consider having some kind of monitoring put in place so that they comply with deadlines and some kind of quality check for their work, just to ensure that the obligations that you as the social landlord has been complied with. Another suggestion is decant properties. So in the event that works cannot be completed within the required time frame, do we have decant properties readily available if a tenant has to move out, or agreements with third-party accommodation providers in the case of an emergency decant? That's something to consider. Next slide, please, John. Okay. My top bullet point here is ensure record keeping is adequate and that where contractors are used, they provide through records of their findings and works carried out at the properties. And what I mean by that is any access issues, which John raised as a potential pretty good defense, should be properly documented. You should properly document exactly what was done, to whom, at what date, and even I would even have a scripted statement to confirm what was done and what stage. Another tip is a clear system to record all dates and decision making with reasons, and that's probably in line with the third point there, recording the basis of decision making to be able to justify later. So those two are pretty much the same thing. What I mean by that is it's a good idea to record your information, share your decisions, share your solutions, and do it in a timely fashion. Don't let it drag. Fourth one is clear records of all attempts to gain access. I've actually already explained that before. So again, fully document who attended, when, what was the result. Final point here is ensure tenants are educated on preventing damp and mold. So you might want to consider the use of smart systems for issues such as heating and ventilation systems, which can feed back data on how installations are working and heating systems are working, extractor fans, and how they're being used by the tenant, which might give you valuable information on how to educate the tenant on how to live in a mold-free environment. John, next slide, please. Right, so this one, central triage unit, which I spoke to John about this yesterday, and the idea was that you have a team, maybe of 2 or 3, and all they do really much is deal with the complaints, taking reports, whether it's online, whether it's over the phone, and this unit just they arrange for the initial investigation, they deal with the initial contact with the tenants. That might be a good idea, has like a designated team. The other one, who's to keep the tenant updated, again, keeping the tenant on board, keeping them updated so they don't feel like their complaint is being neglected, is a really good idea. Consider designated housing staff whose sole role is to contact and to connect with the tenant. That might be an idea. Make provision for weekends leave, as I explained. You've got like 24 hours. You cannot. You have to deal with it over the weekends. Weekends are going to be treated pretty much the same, especially in that initial contact. So you might want to consider making sure that there is always cover at the weekend to deal with any initial complaints. And the last one is make sure make provision for, I've done that one. Make sure teams act mold washers and dehumidifiers. So what I meant by that is you've got to get your team on board here to deal with the complaints, to actively progress the mold washing, any assistance they can give to the tenant in a very fast-paced way. So this regulation, I've said at the beginning, is a game changer because it's my experience of housing, and I've got 15 years plus experience of housing, it is very reactive rather than proactive. This is a time now we have to be proactive. Whether that's going to be something that we're all capable, I don't know, but I think we've got no choice. And the mindset's got to change. And that's my section of the talk.
Hi, so I'm just going to add on sort of a general my thoughts really. So I think one of the things obviously we've discussed is obviously with highways, and I appreciate for housing authorities this is slightly different, but the local authorities particularly, there is always a really strict policy. And I think over the years, most people have developed really structured policies, and most places actually have very similar policies nowadays. And they may mean that we can defend claims because there's a nice clear policy, we know what we're doing, but there's also built in a bit of flexibility, which I think is also really important. So I think that's the starting point, and that's the first step that needs to be taken is everybody needs a policy on how you're dealing with these claims, and all these then steps can fit into it. So whether you have a central triage unit who take in thing or how you deal with it, you need to make sure your complaints department are linking up with insurance or whoever else is dealing with these situations and the people on the ground, and that everybody is aware of how the process is going to work. The record keeping, we will keep banging on about it. I hate to say it, but it is so, so important. And that's the thing on those claims, we can defend them because there's always clear records. If you're making a decision, why are you making it? If you're making a decision not to take action, why are you making it? We need to understand that. And if you've got a policy for reference, then that really helps. One of the things that me and John discussed was a lot of highways policies have pictures nowadays, which is really, really helpful. So they'll have a picture of a particular type of pothole or a particular damage in the road. Now, what you could do is, if it is damp and mold, have pictures and say, right, if it looks like this, to give people an idea to help them. Say, like, we think this is probably going to be more towards a category 2. As we said, we think category 1's probably less likely because it's but it will happen, obviously, unfortunately. So give people the guidance and the help that they need. One of the key ones is probably with access, because we think that actually probably one of the defences will be probably one of the ones we use probably the most. And again, we're slightly guessing this because we don't know yet. Will be the fact of getting access, because that's always an issue in housing claims, as I think we all know well. Make sure you have a policy on how your access works, because it needs to be, okay, if we try on this day, we need to try on X days, and just try and make sure that you understand the structure around it. But also you've got to be sensible in terms of that policy and make it clear. If it's a mum who's got 2 school-age kids and you try and get in at 3:15 every day, she's going to be on the school run. Like, making sure there is actually a practical side to it, because in reality, if you turn around to the court and go, well, we couldn't get access, and they went and they go, well, I was on the school run every single day and you didn't ring me or you didn't send a letter. Or for example, putting something in the letterbox that says we tried to get access, and make it clear again, that's the communication, because you could put we tried to get access about your complaint. Given we've tried X amount of times, we will now not try further access. Please contact us for you to arrange us to get access, that sort of thing, so that you're basically covering yourselves in terms of the process. The other thing that is quite important is considering your risk matrix as to how you respond as well. So part of the legislation is that you have to consider the issue you've got in balance with the tenants. And I think this is going to be particularly important when the further ones come in. For example, the ones Hazel was mentioning about sort of noise and lighting. Now, obviously, most people won't be affected with that. But if you've got someone with particular mental health issues, they're obviously much higher risk. So at that point, you've got your risk matrix. So you need to look at what your issue is versus what your tenant is like. So if you have someone who's got a particular sensitivity to noise, they're going to obviously come much higher up the risk matrix, whereas somebody who isn't will drop down. So again, using your risk matrix to justify your decision and understand and help your staff members understand where they're picking. And again, it's just that justification of going, right, we've got a set structure, we're working within this structure, and that's how we're doing it. And I think that really will benefit everybody. I know I said about weekends and holidays. If you have a weekend when you have loads of complaints and you can't have enough staff out, write it down. At the end of the day, I mean, again, we don't know, but in reality, there is a limit to how many staff you can have available. And it might be that everybody had a complaint on the Saturday. And so you basically run out of people to send. Again, make a note. It may or may not work in a claim. We don't know. But the point is, if you've written it down and said all staff already allocated, attempts made to get further staff, no one available, that sort of thing, that's all we can do. And I think there has to be, we would hope, some reasonable level of adaptation. So I think my big takeaway is get your policies in place now. Build that policy, make it really nice and structured, and make sure your staff are trained and understand it. But also, I think, especially in this early stages, is put them on a regular review for the policies, because the more information we get about how this is actually working in practice, the more you can build into it. So if you do have a policy that's set now, maybe review it in January so that after you've had a bit of experience of how it's working in practice. As I say, just keep those records going, keep the decision, justify your decision making. And I think we do genuinely think there is scope to defend these claims. And I know everyone's been very much doom and gloom, but I think there's more scope out there than we sort of have suggested it, people have suggested in the past. But it's just, we can't defend them unless we know why something has happened and how it's happened and the process that's been followed, because it's all about being reasonable. So I think, yeah, that's my main takeaway. So just on time as well.
Right. Thank you. No, thank you, John, Hazel, and Roxanne. So yeah, really appreciate that. And yes, certainly was an interesting session. Now we do have a bit of time remaining, so now is a chance for any questions, and we've got a few questions from the chat. What I do just want to draw people's attention to, first of all, though, there's a QR code on the screen, so if you would like to provide us with some feedback on today's session, please scan the QR code and that will take you to our feedback form. I'll also post a link in the chat very, very shortly. So yeah, couple of questions. So first question we had was from Simon, which was, we house a lot of tenants who would come under the umbrella of vulnerable, for instance, those with hoarding issues or agoraphobia. It compounds repairs, and in many instances they will not move out. So on Cat 1, would we have to be in court with injunctions? That could be a process that could take months. So are there any suggestions there at all?
Yeah, that actually hopefully is fairly straightforward, because the guidance does say that if a tenant refuses to move out, then that is their choice. But you just need to make sure that you've flagged up the risks to them. So if you just flag up the risks, then you've covered yourself. You don't need to force them to leave.
Right, thanks, John. Right, got another question from Simon, and this is, ASTs are likely to be abolished, but in the meantime, are they covered by the Act?
They would be. I'm not. My gut feeling is no, to be honest. We might have to double check that. I don't think they will be covered. We might just double check that and confirm to everyone, but I'm pretty sure they're not covered.
No problem. Thank you for that. And a question from Paul, who has now left the call, but we can always feed back to him later. So, does the tenant have the right to see the report itself?
I think probably the technical answer is no, because strictly speaking, you've just got to give a summary of your finding. The summary is not the thing itself. So I think that's you've got to communicate adequately, and so a summary may well do the job.
Yeah, that's right, John. Actually, the tenant isn't you're not obligated to show the detailed report, but you are obligated to provide just a brief summary of the findings.
Okay, no problem. Brilliant, thank you. And another question here. So, I would welcome any thoughts, please, on enforcement rights and sanctions. What specialist systems might work for tracking the information, e.g., existing documents might not prompt these measures? I don't know if that's one for us to maybe sort of take away and have a chat about.
Yeah, I'm not totally sure of thrust of that. I don't know if anyone else.
That's fine. I will pick that up afterwards.
Yeah. Okay.
And that's absolutely fine. So, another question from Zoe. So, are risk matrices set out under these changes, or are they independent to each housing association?
I think everyone's going to have to sort of draft your own. We haven't. So in terms of highways, they've been developed by each sort of local authority. Although I think most of them are quite similar now, just because obviously there's a lot of joined up. I mean, it might be one of those things that actually that the housing bodies maybe need. I mean, could look at some sort of joined up approach as to how these things are done, because in reality you're all facing the same issue. But it will be something that will need to be probably developed, which I appreciate is not necessarily the easiest task, but that's how we're looking at it, I think. So.
Brilliant. Right, thank you. A couple of people have asked, can we send out a copy of the slides? So yeah, we will be sending out a recording and follow-up content later this week, as soon as we can following this call. So we'll be happy to share that with everyone. So that was it from the questions and comments that we have got in the Q&A. So if there's nothing further from anyone, then what we'll do is look to end the call now. But really, thank you ever so much for attending. I hope you found that useful. It was really interesting. Yeah, please let us know if you've got any comments, questions, or concerns. And I thank everyone ever so much for their time. Thank you.